Good afternoon, everyone, and welcome. Thank you for joining us for our presentation today on third-party risk management for insurers. My name is Marisa Coggin, and I'm a partner in the Corporate and Regulatory Insurance Group in Dentons Toronto office. And I'm pleased to be joined today by my colleagues Jesse Collins-Swartz, who is a senior associate in the Corporate and Regulatory Insurance Group, and Jansen Fu, an associate in the Litigation and Dispute Resolution Group. So diving right in, today's discussion focuses on third-party risk management for insurers with a focus on navigating today's evolving regulatory landscape. So although this is not really a new topic, we have observed in our practice that third-party risk remains a key focus for federal and provincial regulators, and also one that our clients are constantly contending with in terms of establishing robust frameworks, operationalizing processes to manage third parties throughout the life cycle of these arrangements, and also managing disputes and incidents when they arise. So with that, I will turn things over to Jesse to take us through our first topic of governance and risk management frameworks.
Thanks, Marisa. So good afternoon. As Marisa noted, my name is Jesse Collins-Swartz, and I'm a senior associate in Dentons Insurance Regulatory Group based in Toronto. So I'm now going to provide an overview of certain legal and regulatory considerations related to third-party risk management for federally regulated insurers in Canada. So this is a topic that sits at the intersection of several OSFI guidelines. And, as my colleague Marisa will discuss shortly, provincial regulatory expectations as well. Next slide, please. So before I get into too much of the substance here, I just want to ground us in the definition that frames a lot of what I'll be talking about today. So as you'll see on this slide, under OSFI's guideline B10, a third-party arrangement is defined quite broadly. So it refers to any type of business or strategic arrangement between an insurer, an entity, an individual, by contract or otherwise. And so really the only exclusions here are arrangements with, the insurer's policyholders as well as employment contracts. And I also want to highlight the breadth of this definition because it means that B10, as you know, captures not just your major outsourcing arrangements, but also relationships with brokers, consultants, technology vendors, cloud service providers, and even arrangements with any of your affiliates, subsidiaries. And, it does also capture arrangements that are not expressly in a written agreement. So with that in mind, I'm going to be focusing on third-party risk management in the context of the following two topics. So the first is corporate and board governance. So, what are the governance structures and accountability frameworks that OSFI expects insurers to have in place? And then second, technology and cyber risk management. What are some of the specific controls and contractual provisions you need when you have third-party arrangements that involve technology and cyber exposure. Next slide, please. So as Marisa noted, this topic is quite timely. I did want to highlight OSFI's annual risk outlook for 2026 and 2027 that identifies the concentration and complexity of third-party service providers as a continuing area of concern for OSFI. And so, as you're aware, OSFI does recognize the benefits that third-party service providers deliver. They enable technological innovation, scalable infrastructure, and they drive cost and operational efficiencies that would really be difficult for insurers to achieve on their own. But OSFI is still clear that third-party service providers introduce vulnerabilities, particularly to technology and operating platforms, as well as to data security. And so I want to draw your attention to two items in particular on this slide. The first is that OSFI has signaled that it intends to conduct targeted work in the coming year on the effectiveness of institutions' third-party risk management practices. So we can expect to see active supervisory engagement by OSFI on this front going forward. As well, for the insurance sector specifically, OSFI has indicated that insurance supervision will focus on ensuring that insurers maintain resilient and sound risk management by evaluating insurers' responses to market volatility. That includes oversight of investment, liquidity, and policyholder behavioral risks, conducting supervisory work on cyber preparedness and third-party risk related to critical outsourced operations, and assessing board's effectiveness in overseeing the risk appetite framework and its alignment to ensure strategy, as well as financial and capital plans. So really the message here from OSFI is clear that, third-party risk management, it's not just something that you check off on your compliance checklists. It's really a core component of your operational resilience. And OSFI supervisors will be continuing to actively review how your organizations manage it. Next slide, please. So I'm now going to discuss corporate governance, which, really is the foundation for effective third-party risk management. Without the right governance structures, even the best policies and procedures with respect to third-party risk management will not necessarily be implemented effectively. And so, as you'll see at the top of the slide, OSFI's corporate governance guideline makes clear that to manage risks effectively, an insurer's board and senior management must understand the risks applicable to the insurer's business model, and that includes each business line and product, and how those risks relate to the insurer's strategy and risk appetite framework. And, a central element of this governance structure is the establishment of a board risk committee. And under the corporate governance guideline, the board should be establishing a board risk committee to oversee risk management on really an enterprise-wide basis. And I just want to talk through some of the specific expectations with respect to the board risk committee. So, and acknowledging this is not necessarily entirely new news. So all members of the risk committee, including the chair, should be non-executives of the insurer. The risk committee should seek assurances from the chief risk officer, which I will talk about shortly, or the equivalent role within the organization, that risk management of the insurer is independent from operational management, is adequately resourced, and has appropriate status and visibility throughout the organization. And this is a critical check. The committee, the board risk committee, they're not just passively receiving reports. It's really an active role in terms of satisfying itself that the risk function has the independence and resources that it needs to do its job properly. The risk committee should also be receiving timely and accurate reports on significant risks of the insurer and exposures relative to the insurer's risk appetite, including approved risk limits. And the committee should be providing input on material changes to the insurer's strategy and corresponding risk appetite. Lastly, the committee should have oversight over the manner in which any exceptions to risk policies and controls are identified, measured, monitored, and controlled, as well as how exceptions and breaches are addressed. Next slide, please. So, closely related to the board risk committee is the appointment of the chief risk officer or an equivalent senior officer within your organization. And under the OSFI corporate governance guideline, the chief risk officer or CRO is really the head of the insurer's risk management function and is responsible for the oversight of all risks across the business. And so I want to flag the following with respect to the chief risk officer. They should be someone with sufficient stature and authority within the organization and really should be independent from the management of the insurer's operations. They should have unfettered access and a functional reporting line to the board or the board's risk committee. They should not be directly involved in revenue generation or the management and financial performance of any business line or product of the insurer. And similarly, their compensation should not be tied to any of those performance-related metrics. The chief risk officer is expected to provide regular reports to the board's risk committee, and senior management. And they should be meeting with the risk committee or the board on a regular basis. And this includes with and without the CEO and other members of the insurer's senior management being present. Next slide, please. So on the next two slides, I'm going to take certain key corporate governance principles, and then I'm going to be translating them into a practical allocation of responsibilities across the insurer's organization. I do want to flag that the allocation of responsibilities is not really intended to limit the number of stakeholders that may be involved in certain of these categories that I'll be discussing. The framework is flexible and, the accountability, consultation, and information responsibilities may differ depending on how exactly your organization is structured. So starting with governance and accountability, The board and the C-suite are responsible for establishing a culture of compliance, what is often called the tone from the top. And this includes the board's risk committee. The business side of the organization is responsible for the day-to-day implementation, and the insurer senior management should be satisfied that business activities, functions, and services performed by third parties are being done in a safe and sound manner and in compliance with applicable legislative and regulatory requirements, as well as the insurer's own policies and procedures internally. Regarding the third-party risk management function, the chief risk officer will set the risk appetite and will dictate the framework in consultation with compliance and will oversee the ongoing review and updates to the framework. The business is then responsible for the actual implementation of the framework itself. And on the regular assessments of the insurer's existing third-party arrangements, the business is responsible for conducting those assessments, but then reporting any issues to compliance and then having the proper escalations to the chief risk officer, and then in turn to the C-suite and the board where material issues are identified and need to be rectified. Next slide, please. So continuing on here, for identification and assessment of risks, compliance will set the parameters and dictate the necessary assessments, while the business will conduct risk assessments of third parties, both before entering into an arrangement and during the term of the arrangement. And then for highly critical service providers, this may also include conducting audits of the arrangement. For monitoring and assessing performance, the business will be responsible for assessing third parties on a continuous basis. Compliance is responsible for testing and assessing controls, and compliance should also be working with legal to ensure that contracts, especially ones for highly critical services, contain provisions that allow for audits along with other terms and conditions that will promote the insurer's ability to monitor and assess risks with the arrangement. And then internal audit will provide periodic independent assurance. Regarding technology and cybersecurity, IT is responsible for implementing the necessary processes and safeguards, and the business is responsible for ensuring the third-party technology and cyber operations are reliable and secure. And compliance and legal are responsible for ensuring that contracts contain the terms that are required by OSFI, including provisions dealing with confidentiality, availability and integrity of records and data, as well as the requisite data breach notification requirements. So really kind of an overarching point from what I've been discussing here on corporate governance, really third-party risk management, it cannot be siloed within any specific function or department of your organization. It really requires coordination across the board, including the directors, board of directors, the C-suite, the chief risk officer, compliance, legal, IT, business operations, and internal audit, among others. And so, each department will have a defined role, but really effective third-party risk will require that all of those departments and others work well in a coordinated manner together. Next slide, please. So before I move on from corporate governance, I do want to flag an important OSFI-related development applicable to insurers conducting business in Canada. And in January 2026, OSFI announced that it's reviewing its suitability and accountability expectations for senior leaders of federally regulated financial institutions, including insurers. And OSFI expects to establish a new senior leader regime to modernize suitability expectations and introduce strengthened accountability measures. And the intended outcome of this regime, according to OSFI, is the clear assignment of responsibilities, oversight, transparency, and accountability among the senior leaders within the organization. And under this proposed regime, insurers would be expected to develop, implement, and maintain their own accountability framework for senior leaders. And this would be drawing on existing governance documents, risk management structures, and internal control practices. And then this accountability framework would need to be updated and approved by the board and submitted to OSFI annually or as requested. One really important thing to note here as well is that this framework is still in the consultation phase, and OSFI is accepting industry feedback on the proposed accountability framework until October 31st, 2026. And we continue to monitor developments on this topic. Next slide, please. I'm now going to briefly speak to technology and cyber risk in the context of third-party risk management. And so this is really an area where there's two OSFI guidelines that are working together, Guideline B10, as well as Guideline B13, the Technology and Cyber Risk Management Guideline. I acknowledge certain aspects of this guideline, especially around data security and privacy, are highly technical, and I'll only be touching on certain high-level points here. And so I did want to flag three key expectations in Guideline B10 that should be included and taken into account when entering into third-party arrangements. And so the first is establishing clear roles and responsibilities for technology and cyber controls. So the roles and responsibilities established will really depend on the risk and criticality associated with a particular arrangement. And for higher risk, higher criticality arrangements, OSFI expects more granular descriptions of the roles, responsibilities, and procedures to be established between the parties and included in the contract. The second expectation relates to third-party compliance with insurers' technology and cyber standards. So depending on the level of risk and criticality, insurers should establish processes to monitor and confirm that third parties with greater technology and cyber risk exposure comply with the insurer's own standards or with recognized industry standards. So this includes implementing audit processes and securing audit rights within your contracts, as well as mitigating risks related to access management and data security. So the third expectation relates to cloud-specific controls, and insurers are expected to develop specific technology and cyber controls related to cloud systems. And these should draw from existing controls implemented by the insurer, including data protection, key management, container management. And insurers should also consider the portability of cloud platforms and the level of concentration risk involving cloud platforms used by the insurer. So that is really the risk of over-reliance on a single cloud service provider. And B10 specifically expects insurers to consider strategies such as multi-cloud design to build resilience and mitigate the cloud service provider concentration risk. So thank you for your time, and I will now turn things over to my colleague, Marisa.
Great, thanks, Jesse. So now that we have the framework and governance of third-party risk management in mind, we'll discuss the life cycle and some operational considerations that allow for fees to meet their own regulatory or obligations when they're entering into third-party arrangements. So the next slide has a few different phases, which are not always a one-time situation. So the initial phase very clearly involves risk identification, third-party selection, and due diligence or screening. However, that's not the only time that diligence or risk assessment occur during the third-party life cycle. There should be ongoing diligence and risk assessment, given that arrangements are seldom stagnant. They often change. New risks can be introduced because of changes at the third party or even at the carrier level or even perhaps at a subcontractor level. So in terms of the formal onboarding process, that is the point where you have determined you wish to proceed with a specific third party. You're entering into a written contractual arrangement, and that is informed by the risk assessment and diligence that's been provided. The goal with that process is to position the carrier to meet its own legal and regulatory expectations, as well as protecting its own commercial, reputational, and other interests. Inventory and risk register is also very key to this part of the process because that is how you can assess concentration risk on an ongoing basis. And also that applies to subcontractor risk as well. And that concentration risk can be by provider, or it can be geographic or another factor. And a good example of this, which we'll touch on later in the presentation, tends to be in the artificial intelligence space, where there does tend to be concentration in AI providers. And then towards the end of today's presentation, we'll touch on incident management as well as disputes and termination considerations. So moving to the next slide. In terms of selection, your procurement process from an integrity and security perspective should be objective. The specific selection criteria you are relying on or using is going to vary based on the type of arrangement or third party that's being selected. So there's going to be additional considerations for parties like distributors, which I will touch on. But another thing to note is that we've observed for the larger global insurers, a lot of material third-party arrangements or relationships tend to be done or completed globally rather than by the local team in Canada. So those teams globally do need to be aware of any Canadian specific requirements. And similarly, the Canadian team needs to be aware of that arrangement impacting, if it's a Canadian branch, for example, the branch and how a disruption could impact Canadian operations. In terms of diligence, I'll go into more specifics on this in terms of what is needed to build out your diligence questionnaires and request forms. But I mean, the crux of it is the business needs to know what information is relevant to collect and evaluate, or the contract owner, as the case may be. So to do this effectively, we find it's usually very helpful to provide forms, training on an ongoing basis, and to keep in mind that the extent of the diligence necessary is again going to develop or depend on the nature of the arrangement, as well as whether the third party has access to confidential information or data, IT systems, or even the physical premises of the carrier. On the risk assessment piece, the key here is being able to assess and document after the fact whether the services or functions or activities that are being provided by the third party are being done in a safe and sound manner, whether it's in compliance with laws and regulations, as well as how it aligns with your internal policies at the carrier level. So moving to the next slide. Distributors are a very common type of third-party arrangement for many carriers, so we thought that we would discuss that briefly. The Canadian Council of Insurance Regulators, or the CCIR, conducted a review of monitoring and supervision practices of insurers, and their overall conclusion with respect to distribution channels was that there could be more enhanced monitoring or supervision. And so they put out some recommendations, and part of this involves enhancing the selection and assessment criteria you use with respect to your distributors, considering which conditions you need to impose if you do find certain things in the diligence process that warrant conditions being imposed, follow-up processes for remediation, specific questionnaires, and periodic oversight controls. The key here is that all of this should be done or in process before the formal onboarding process so that everything is in line and all the contracts are informed by the diligence and the screening that's been conducted. So moving to the next slide on due diligence and screening. This is a very high level set of minimum information. Guideline B10, which you're likely familiar with, has an extensive laundry list of due diligence considerations, but these are things that I find tend to apply to many types of arrangements and help inform the level of diligence, the screening, and the monitoring that's going to be required for these third parties. So the request lists are typically developed by the compliance and or legal team, depending on your organization. The actual information is then collected by the contract owner or business line or a different department, perhaps licensing, or if it's a distributor, for example. So the diligence questionnaires that you provide to your teams can vary by type of arrangement. They can be tailored by degree of risk, whether it's high, medium, or low risk. Some engagement is likely required with the risk team to determine whether certain arrangements fit on one side of the spectrum or the other. And then I just want to draw your attention to, material subcontractors. It is really important to consider what information you need from those subcontractors, as well as implementing that request list in your questionnaires. Next slide, please. So some of these issues are black and white. Some findings are more gray. Personally, I tend to live in the gray as a regulatory lawyer. So it's very often the case that questions come to us that don't have a clear answer as to whether you should proceed or not. For example, conflicts of interest are one that are always tricky. Sometimes they can be present, but they can be manageable depending on the type of arrangement. The key in that respect is obviously being aware of the conflict, documenting how it's going to be managed and ongoing monitoring to determine how that is, if that is actually being managed in the way that is required to be. And, I think for the others, it really depends on your internal processes and risk appetite as well. Certain things are non-starters, like criminal convictions, particularly if they're fairly recent or they relate to fraud, as well as lack of monitoring or security posture. So internally, to operationalize this, there should be protocols that either block the arrangement from proceeding if issues are flagged, or protocols that lead you to or lead the contract owner to have to seek additional approval, especially if it's a material contract, so that you can manage risk appropriately internally. Next slide, please. So once we've reached this stage where we are formally onboarding a third party, as mentioned, this is where you get into written contracts, considering the scope of your SLA reviews, your audits. We'll go through some of the contractual provisions in the next set of slides, but this is also the point where you need to figure out and put in writing and instruct properly on what check-ins the business or contract team should be doing, what information they need to be collecting on an ongoing basis. This is, as your first line of defense, that's often the best way to manage risk proactively. This is also the point in time, as mentioned earlier, where you need to have an inventory of your arrangements. So you need to be tracking concentration, risk, and other exposures, especially on the subcontractor side. If it's an AI model, you will also have to update or consider updates to your model risk register, which is an upcoming requirement in guideline E23 next May. And in terms of document retention, I just want to highlight that's the best way to demonstrate and evidence that you're following protocols and assessments and that you're conducting everything in line with your internal requirements. And that also feeds into your regulatory compliance management process, which is, of course, another area that OSFI is looking at this year. Next slide, please. So the next couple slides just have examples, very high level of provisions that are typically needed to protect carrier interests and ones that we find are negotiated more heavily. B10 again has a laundry list of suggested provisions that should be in every third-party contract. These again will vary depending on the nature of the arrangement and its materiality. So it's always a good idea to loop in legal early, as they will either have a role in reviewing the contract or perhaps they are providing templates depending on the nature of the service that's being provided. Input from the business line and subject matter experts, however, is critical, especially on operational and commercial points, and in particular on arrangements that are more complex and deal with IT and security related features or AI features. Next slide, please. So this is a very basic example of an audit rights provision. It's not intended necessarily to be utilized. It's just here for illustrative purposes. But depending on the IT considerations of the specific arrangement, you would need to build that out to determine, what specific things you want to audit, at which intervals, what other rights you'd like to have. And of course, giving OSFI or other regulators the right to audit as well. The contractual rights and obligations with respect to information and data access, as well as business continuity, need to be clearly laid out, especially on the business continuity side if it's an exclusive arrangement or if the vendor is not easily substituted. Incidents and events that impact or can impair the services or impact your customers or clients would need to be reported, whether that's at the third party level or at a subcontractor level. So that also needs to be inserted into the contract. On the next slide, we are touching on background checks and subcontracting. So I think I've talked about subcontracting quite a bit, but essentially it's important to have the right to vet and approve all subcontractors, particularly if the third party is relying on any subcontractors to provide the service or the function or activity to the carrier. On background checks, that really goes to integrity and security, as well as potentially if it's more of a distribution type role or similar or interacting with customers, it could have market conduct and suitability impacts. And the carrier needs to know who is being relied on to perform functions and activities, and also whether those people have been assessed in line with their own internal protocols. So moving to the next slide, when we talk about ongoing monitoring, I think the key here is really feedback and communication between the first and second lines. Next slide, please. Thank you. So that's very important, not just from a reporting perspective, because of course you need to have the first line reporting up to the second line in order to determine what gets reported to C-suite, branch management, the board of directors. But it's also to tailor and improve the overall risk management process. And what I mean by that is arrangements don't stay the same forever. They often change. Perhaps the carrier's needs change. They request enhanced services or different offerings from the third party, or the third party is able to do things with new technologies that it wasn't able to do before, all, in a way to improve the activity being, or the function or activity being provided. The business lines are able to notice these and notice trends as well and inform the second line of operational realities. So I do think it's really important to keep those that feedback line open. Next slide, please. So back to the CCIR report, just briefly on distribution channels and monitoring and supervision. So on the distribution side, the report does have some recommendations on monitoring and supervising distributors in particular. Some of these are, I would say, pretty helpful, especially on establishing, the annual or periodic statements by distributors and what information you should collect. So I would recommend having a look at that for your distribution specific arrangements, as well as if you are on the life side, the life insurance side, there's some specific guidance and tools on the CLHIA website that are helpful. Next slide, please. So AI, everyone's favorite. I drafted this slide before the technology risk bulletin on Gen AI and agentic AI came out late last week, I believe. So it didn't actually change very much because I was basing this off of a consultation paper that the FSB has out right now on responsible adoption of AI. But I would like to highlight, many of these things and the risks that are being highlighted in the AI specific realm are things that are already present in a lot of ways in your third-party risk management frameworks, or should be, or contemplated in those frameworks, but they're just enhanced. For example, the failure of a third-party AI system to perform as expected. You likely have protocols already with respect to failure of a service provider to perform, but these are enhancements that need to be considered with the scope of AI or the lens of AI. The insufficient transparency piece with respect to training data as well as data governance, I think are really new risks and AI specific risks that your specific or technology specific experts need to have a look at and consider how they're going to build out processes and protocols operationally to address those risks. The other thing I would say is that OSFI's recommendations in the bulletin or observations on risk control and mitigation are worth having a look at, specifically on testing AI failures and outages, assessing portability and enforcing obligations with your third parties regarding whether they're using AI and how they're using AI to provide any services. Next slide, please. So incident management rather, and the incidents that relate to that could be those described in B10, and they may be reportable to OSFI or the RCMP or other external bodies, but they can also be things like unauthorized distribution. They could be authority breaches, it could be fraud, it could be unethical practices by the third party. So it's really I'm using the term incident quite broadly here. So I do think in terms of your incident management plan, you should have clear processes to report and escalate any material incidents, again, whether it's reportable or not. And also consider including subcontractor incidents as well. The carrier should also have a contractual right to assess the root cause of any incidents and get that analysis from the third party. So I'm going to wrap up with the last slide. If an incident is reportable under the OSFI Technology and Cybersecurity Incident Reporting Advisory, you do need to make sure you have clearly established roles and responsibilities of the parties, whether it's at the subcontractor level or the third party level, for managing those risks and the associated controls. Specifically, you need to make sure that you will be in a position as the carrier to receive all that information when an incident occurs, and also the follow-up information and remediation so that you can meet your regulatory expectations. So with that, I will turn it over to Jansen to address managing and mitigating disputes with third parties.
Thanks, Marisa. So my name is Jansen. Thank you for the introduction, and I am an associate in the Dentons Toronto Litigation and Dispute Resolution Group. So today I'm here to talk about dispute management, termination considerations, and more particularly in the litigation perspective, preserving privilege when it comes to disputes that have escalated and there's reasonable anticipation of litigation. So if we could move to the next slide, please. Thank you. So starting off with sort of mitigation of best practices, my colleague Marisa already spoke extensively on it, and mitigation really starts prior to and at the beginning of the relationship with third parties. So before you enter into any relationship with a third party, you should be conducting rigorous due diligence and before you reach the onboarding phase, and even throughout the onboarding phase, you should continuously assess the type of risk that you are willing to take on by entering into these relationships. So what that means is there's, of course, extensive due diligence checklist that you can follow, but you should really be determining and reviewing their documents for things like financial stability, regulatory history, any complaints, litigation history, qualifications to important individuals in the third party to make sure that their capabilities align with what you are expecting. So it also means looking at sort of downstream arrangements and ensuring that if like the third party has the ability to delegate or does in fact delegate or subcontract to other parties, you should have visibility into that chain. So having a well documented due diligence process and onboarding checklist creates or mitigates risk for you down the line by establishing a record and showing that you've exercised the requisite level of care in selecting the third parties that you're entering into agreements with. And also it matters later on if a dispute arises and you need to defend your position in why you decided to at first entrust the third party with whatever business that you're conducting. So there is a lot of overlap with what Marisa has spoken to, so I'll speak on it at a high level, but one of the most important things that you can do for risk management and mitigation is building in those contractual rights at the very start. So you should be thinking about adding in rights for conducting audits and expectations and having access to the third party's books and records on short or without prior notice. These are all things that allow you to continually assess the risk associated with the relationship you're in, and also making sure as things change, the relationship is very dynamic. You're on top of any potential disputes that may arise, or any flaws in third parties' operations that could lead you to think about potentially terminating the relationship later on. So other things to consider: having clear reporting obligations with defined frequencies and formats, covering the activities of the third party. It's important to note that, at least in the contract development phase and formation, it's always easier to negotiate these things up front and to build these protections in for your business early on. It's a lot more difficult to do that after you've entered into the contract and the relationship is under strain. So the contractual arrangement is your best sort of protection to ensure that you are able to mitigate any risk later on. So the third point, reviewing third-party policies and procedures, that just ties in with the due diligence and onboarding phase. It's just really important before you enter into any sort of third-party arrangement that you are conducting a very rigorous due diligence process. The last point is, again, you just want to make sure that you're documenting all sorts of correspondence, any records that relate to material adverse issues as they arise. It may not necessarily be the case that something will arise to the level of litigation immediately, but if you do encounter uh, adverse issues, it's important to have a written record, especially where if something ends up being litigated before the courts, you know, recalling your memory is not as persuasive or informative of having a written documentary record to rely on. Next slide, please. So this slide, speaking onto reputational and litigation risk, these are two factors that don't always necessarily move in the same direction, but they require important consideration. Speaking to reputational risk first, anytime there is a material adverse issue and you are deciding how you want to respond to it, you will first need to assess the type of risk exposure that you have. So factors you might want to think about are public visibility into the type of issue that you're facing, possible degree of regulatory attention, and the extent of potentially customer harm. Those are all factors that would inform the type of reaction that you would have from a reputational standpoint. And that goes to responding proportionally and consistently. Some disputes and some issues you may not necessarily need to react. You should always react consistently and proportionally, but overreaction or underreaction can undermine the type of reputation you have to important stakeholders and to the broader public in general, and may attract regulatory scrutiny. In terms of managing reputational risk, if it gets to a point where issues are escalating and you've identified that there is a potential that the issue will become something litigated down the line, it's important to involve legal early. Having legal involved, whether in-house or external, that helps mitigate risk, because once legal is involved, they're able to vet the types of communications you have, the types of responses that you do, and then they can provide input in terms of strategic decisions to mitigate litigation risk down the line. For example, if you're preparing third-party or external-facing communications, legal can provide input in terms of what you want to put out there, whether that may be an admission, or, for example, you may make a statement that may be accurate, or so you may make a statement at one point in time, and down the line, you may need to take a contrary position to defend in a dispute, and now you're faced with an admission that you made previously. So if you have legal involved, they're able to kind of issue spot these and prevent litigation risk from arising, or at least mitigate against it down the line. Litigation risk here, as I've said, having legal involved, they'll be able to make sure that any responses, any communications are done in such a way as to mitigate any potential counterclaims or track like regulatory investigations, any of those things down the line. Yeah, one factor to consider, it's important to once a dispute has gone to a certain level where it is now material, it's important to identify the relevant parties and get onto document preservation and privilege control as soon as you can. And that's going to be something to speak on later in my next slides, but it's important to identify as soon as you can the relevant individuals in your business that have key information, and kind of insulate them and their information from being disseminated more broadly. It affects privilege concerns. You may end up inadvertently waiving privilege, and you just generally don't want to have confidential information or too many individuals involved on the business level in dealing with a dispute, just because it gets, again, there's risks with waiving privilege that you just want to avoid. So identifying early on who are the key individuals to insulate, that's important. Next slide, please. Practically speaking, privilege is one of the biggest things that you want to be concerned about. Privilege in terms of disputes, there's really two that you really need to be concerned about. There are other types of privilege that protect communications, but the most important and most broad is solicitor-client privilege. So as a refresher, solicitor-client privilege just protects confidential communications between a client and their lawyer for the purpose of obtaining or giving legal advice. So the elements of solicitor-client privilege are set out there. First is that it needs to be communication between a lawyer and a client. Communication has to be confidential. So if a third party is, if the communication was made at a time where a third party that isn't a party to that lawyer, like solicitor-client relationship, is aware and has knowledge of it, then you may have inadvertently waived privilege because that communication is no longer confidential. So it's important that communications, once you've involved legal, they stay between the relevant individuals in the business level, which is why, going back to my earlier point, it's important to insulate and identify who are the key people for dealing with a dispute. The third point is communications has to be for the purpose of seeking or providing legal advice. So this is important. It's a nuanced distinction because there may be times where you're speaking with a lawyer, like in-house legal, and unless it's for the express purpose of seeking legal advice, those communications are not presumptively privileged. So if you're speaking to, for example, like internal legal counsel, but they're giving you more business advice, then that communication isn't privileged just because you're speaking with a lawyer. One important point about the privilege between solicitor clients is that it lasts forever. So even when the solicitor-client relationship has been terminated, that information is still privileged. It cannot be used against you. The client is the one that has the ability to waive the solicitor-client privilege, not the lawyer. So any information that is privileged is protected as long as it hasn't been inadvertently lost or waived. Next slide, please. Litigation privilege is the second type of privilege that is most relevant, and in some ways it's broader than solicitor-client privilege, and in some ways it's more narrow. It protects documents and communications created for the dominant purpose of existing or reasonably anticipated litigation. All that means is that if there's communications or documents are created when there is ongoing litigation, it's created for the purpose of that litigation, or you reasonably expect that litigation will result and the documents being prepared for that, it's protected by litigation privilege. Can't be compelled for disclosure. So again, dominant purpose has to be for existing or reasonably anticipated litigation. The privilege is broader than solicitor-client privilege because it can be asserted against third parties. What that means is that if legal or your internal counsel or external counsel have engaged third parties expressly to deal with a dispute, for example, independent experts or auditors or investigators, like those documents, those reports, those communications are protected under litigation privilege. So whereas for solicitor-client privilege, that is only privilege as between communications between the client and the lawyer. So you can't extend it to third parties. Another distinguishing point is that litigation privilege only lasts as long as the privilege or as long as the litigation is ongoing. Once the litigation terminates, then those documents, correspondence, communications are no longer protected by litigation privilege. They may still be protected by solicitor-client privilege if that applies, but if it was, for example, an independent report that was prepared for the express purpose of dealing with litigation ends, that report can now be producible. So these are important things to keep in mind when you're trying to manage a dispute on the business level, and you want to make sure that you're protecting or preserving as much confidential and privileged communications as possible. Next slide, please. So generally, you should just be treating privileged information the same way you treat commercially sensitive information. This is not only important to protect to protect the advice that you're given and the decisions that you make in managing and dealing with legal disputes, but also it just shows that you are complying with your own, like you have internal processes that you're able to comply with and that are rigorous and protect the information that that you're seeking to assert privilege over. So first point, these are just some points in terms of how you should treat and considerations you should have for privilege information. Like generally, privileged information should not be easily accessible. That goes back to the point of making sure that once you've identified the core people that are relevant to a dispute, you should generally limit access to privileged information as between those people and then in-house or external counsel. Tight controls, you should have tight controls over who may access the privileged information. And there should also be guidelines and thought to how you want to duplicate, transmit, or reproduce privileged material. Yeah. Again, one of the hidden pitfalls of communications in large businesses, especially with legal, is that you may inadvertently waive privilege over confidential documents or communication just by the scale of how large your business is and how many people may be involved. So that's why it's important to make sure that only limited individuals in your business have access to the privileged information. Right. So we're on the next slide. What do you do once you've gotten to a point when you're considering terminating the third-party agreement? So these are factors that you should consider. And I think the most important thing is that if you are going to exercise termination rights, it has to be done in accordance with the contract that you have in place. So important things to consider are when you're entitled to terminate. Generally, contracts will have for cause termination provisions or without cause termination. The only difference there is that in for cause, there must have been some sort of event. For example, breaches of representations of warranties or breach of the contract, or perhaps regulatory investigation has been commenced against the third party. That would entitle you to terminate for cause, and generally you're able to terminate immediately. Alternatively, there's termination without cause, where it allows the insurer to terminate for whatever reason that it wants, as long as it provides like a notice period. And generally, those notice periods are anywhere from 30 to 60 to 90 days. It's important to make sure that if you do terminate, you're complying with the form and the notice periods in the contract. If you don't do that, what ends up happening is that you may have exposed yourself to a counterclaim through counterclaim for breach of contract or breach of the duty of good faith or honest performance for terminating the business arrangement without due notice. So, or causing them damages in the form that you've terminated, and now they may have a claim against you. It's about mitigating your litigation risk, because if you terminate, your relationship has likely hit a point where the relationship is under strain, and more than likely, if you terminate an agreement, you may face the risk of litigation in return. So it's important to make sure that your decision is as defensible as possible, because it's conformed with the agreements or the provisions in your contract. Another thing to think about is whether there's obligations to allow third parties to cure default. So if that's the case, it kind of works like a notice period. You just want to make sure that if you want to terminate, you comply with like the obligation to allow the third party to cure that default. And if they fail to do so, then you're entitled to terminate. Next slide, please. So when you prepare to terminate, as with any risk mitigation procedure or process, you should make sure that you have a well-established record to support your decision. So what documents, facts, or events that have occurred leading to your decision, and are you able to produce or have a written record that demonstrates and supports your position if this ends up going through litigation. So another factor to consider: transition plans. When you terminate things, you can terminate things and you'll be legally entitled to terminate, but then there may be business factors that apply following your termination that may have a greater fallout. So to the extent that a transition plan hasn't been considered, those are things that you should always think about. If you need to transition services from one third party to another in light of the termination, what has your business done to think about those factors in advance of the termination? Audit points, if you conduct an audit, that can just support your position later on if it comes to litigation. And again, the last couple points is just that termination always carries litigation risk. So you can mitigate that risk by being as prepared as possible, having written documents that support your decision, and then also anticipating the third party's reaction, planning accordingly there. Next slide, please. So post-termination, just to touch on it briefly, as I know we're coming up on time, is that you want to make sure, just like how if you're going to terminate the agreement, you follow the form of the contract, you need to ensure that you are complying and third parties complying with surviving obligations after the termination of the agreement. So, for example, there may be indemnification provisions that apply. There may be obligations to comply with regulators or obligations to allow final inspections or return documents, preserve or destroy confidential information. So these are all things that need to be considered before termination, and also the business should be aware of it post termination. You should also notify relevant stakeholders who've been that need notification, work with your legal in that sense to tailor the communication to the types of stakeholders that you have to notify so that you can mitigate risk to the business post termination. As with every termination, it's always an opportunity to strengthen your risk mitigation protocols. You can, if you end up through litigation or there's disputes that arise from the termination, you can reflect on it, modify your own internal processes and procedures so that going forward, you have a more defined process when you're dealing with terminations of third-party arrangements in the future. So I believe that is my last slide, so I'll turn it back to Marisa for closing remarks.
Thanks very much, Jansen, and thanks to all our speakers for those valuable insights. We'll move into the question and answer portion of the session. Please feel free to submit your questions if you haven't already done so to the Q&A panel. Given we only have a minute or two left, I will try to address as many as I can. We had a question on what FREs need to do with respect to situations where the FERFE is dealing with hyperscalers like Microsoft, Anthropic, etc. I think on this, there's a few things. This is definitely a larger conversation, but a lot of those contracting parties that you would be dealing with would inevitably be providing you with standardized contracts that are often not easily or, accessibly negotiated. And I think that's contemplated in B10. So it's not that, there's an expectation that you'll be able to negotiate all the terms and conditions necessarily, but more so that there needs to be appropriate mitigation and monitoring and tools in place internally if you do decide to proceed with those parties. But I do want to thank the panelists again and to all of you for joining us today. I hope this session has provided you with practical business-focused strategies for managing third-party risk. So thank you again for your time and engagement. We look forward to connecting with you again soon.